Welcome to the Deep Dive. Today, we're taking on something really fundamental. We're going to explore what should be the bedrock of the American constitutional system, popular sovereignty. And we'll track how this idea that the people are the ultimate authority seems to have been, eroded over time. Specifically, we're looking at the role of the courts and this now common idea that the Supreme Court has the final say on what the Constitution means.
It's a critical topic because, the power to interpret is immense.
Yeah.
As William Watkins points out in his work, Judicial Monarchs, there's this huge puzzle right at the founding. Why did the founders, these incredibly sharp minds designing a whole new system based on a written constitution to limit power, why did they stay silent on who gets the final authority to interpret that very document?
Right. It seems like a massive oversight, but it couldn't have been. They knew that the interpreter ultimately controls the meaning. They'd just fought a war, partly over the interpretation of rights under the unwritten British Constitution.
Exactly. That silence wasn't an accident. It was almost certainly a deliberate choice. And it stemmed from their understanding of power and the options available. They essentially saw two possibilities for how constitutional interpretation could work in this new republic.
Okay, so the first one is basically what we have now, right? The Supreme Court decides, and everyone else just falls in line about Congress, the president, the states, us.
That's the modern view, yeah. Judicial supremacy. And look, if they'd wanted that, it'd have been easy enough to write down the Supreme Court's interpretation is final and binding, simple. But think about it. That would have run completely counter to the whole point of the revolution, self-rule, and the core principle they were building on, separation of powers.
They didn't want to just swap King George for 9 judges in black robes.
Precisely. They weren't looking to concentrate ultimate interpretive power in one branch. So the alternative, the one consistent with separating powers.
Yeah.
What was that?
That must be the system implied by their silence. Each branch interprets the Constitution for itself within its own sphere of action.
That's it. The courts would have a role. Judicial review, yes. They could look at a law when deciding a specific case and say, hang on, this conflicts with the Constitution. But that ruling applied to that case. It didn't automatically bind the president or Congress unless they also agreed with the court's reading. They had their own independent duty to uphold the Constitution as they understood it.
Co-equal branches, co-equal interpretation, checks and balances, not judicial monarchy.
Exactly. The silence meant the default applied. Co-equality.
Okay, before we dive into the history that really backs this up, let's nail down these terms.
Yeah.
Because words like judicial review and judicial supremacy get thrown around and often mixed up. Watkins makes some crucial distinctions.
Absolutely essential. First, popular sovereignty. This is the big one, the revolutionary idea. It means the ultimate, final, unlimited source of authority is the people. Period. Government officials, judges included, are just agents, trustees, servants exercising powers the people delegated to them through the Constitution.
The people are the boss. The Constitution's the job description.
Couldn't put it better. Second, judicial review. This is the power the courts have when hearing a case to compare a law to the Constitution, and if it's clearly violating the people's instructions, refuse to enforce it in that specific case. This is totally consistent with popular sovereignty. It's just one agent, the court, checking another agent, the legislature, against the principles, the people's rules.
Okay, so popular sovereignty is the foundation. Judicial review is a tool consistent with it. What's the problem then?
The problem is the third concept, judicial supremacy. This is the modern doctrine, the idea that developed later. It says the judiciary isn't just a co-equal interpreter, but the final, ultimate binding interpreter for everyone. The court sits above the other branches and effectively above the people themselves when it comes to defining fundamental law.
And that's fundamentally at odds with popular sovereignty. If the court is the ultimate sovereign, the people aren't.
Precisely. It's anti-republican at its core.
So, our mission today is to trace how we got from that original design, popular sovereignty with co-equal judicial review, to this modern reality of judicial supremacy. To really feel the impact of what the Americans did, we need to quickly look at the systems they were reacting against. Let's trace that idea of sovereignty.
Right. You have to start in Europe with the divine right of kings. Think James I of England. He genuinely believed and stated that he was a judge set by God over them, answerable only to God.
And he wasn't shy about it, lecturing Parliament that laws were properly made by the king alone, that kind of absolute claim. Well, it didn't end well for his son, Charles I.
No, it led straight to the English Civil War and Charles losing his head in 1649. But the idea of a single ultimate authority was powerful. Jean Bodin, the French thinker, argued that sovereignty had to be indivisible.
Indivisible what?
Bodin believed that if you divided the core powers, making war, taxing, coining money, you'd just have endless conflict. So sovereignty had to reside in one place. Could be a king, could be an aristocracy, could even be the people, but it had to be one entity. No sharing, no internal checks on the ultimate power itself.
Okay, so that's the theory. And in England, after the Glorious Revolution of 1688, where did that indivisible power land?
It landed squarely in Parliament. They effectively swapped one supreme ruler for another. This is parliamentary sovereignty. William Blackstone, whose commentaries were hugely influential for the American founders, described Parliament as having sovereign and uncontrollable authority. Absolute despotic power had to rest somewhere, he thought, and in Britain, it rested in Parliament.
Meaning Parliament could do anything, pass any law, however unfair, and no one, not the courts, not the king, certainly not the people, could legally challenge it. The courts had zero constitutional role.
Exactly zero. And this is the system the American colonists lived under and ultimately rebelled against. Their experience with things like the Stamp Act, the Townshend Acts, taxation without representation, it showed them the danger of any government body holding that kind of ultimate unchecked power.
So the revolution wasn't just about taxes, it was about fundamentally rejecting that whole model of sovereignty.
That's the key insight. They rejected the idea that any government institution could be the ultimate sovereign. Power had to be divided, limited, and crucially, grounded in the people. The mechanism they used was brilliant. Popular conventions. Starting in places like Massachusetts, the people themselves, in special conventions, not the existing legislatures, debated and ratified their new written constitutions.
That act itself established the people as the ultimate source of authority above the government they were creating.
Precisely. Legislatures, governors, judges, they all became mere agents, exercising only those powers the people explicitly delegated in the written constitution. St. George Tucker, a hugely important early American legal scholar, said it plainly. The people possess sovereign, unlimited, and unlimitable authority. The government works for them, not the other way around.
Okay, so if the people are sovereign and the legislature isn't omnipotent like Parliament anymore, what does that mean for the judiciary? A branch that Montesquieu kind of dismissed as next to nothing in the English system.
Well, it means the judiciary, like everyone else, is bound by the Constitution and the separation of powers doctrine. Articles 1, 2, and 3 lay out distinct roles. The judiciary's job is judging cases, not making laws. They aren't given legislative power.
And because they weren't explicitly given supreme interpretive power, which would be a form of legislative or superconstitutional power,
the assumption had to be the default. Co-equality. Each branch interprets the Constitution as needed to perform its own duties. If they meant for the judiciary to be supreme, they would have had to spell it out, precisely because it went against basic separation of powers theory.
And we actually have evidence of this thinking before the federal Constitution, right? From early state court cases.
Yes, Watkins brings these cases to light, and they're fascinating. Look at Commonwealth v. Caton in Virginia, way back in 1782. Even before the Federal Convention, Judge Edmund Pendleton, a major figure, wrestled with this. He called the question of whether courts could strike down a law deep, important, and tremendous.
Tremendous. Why? Tremendous sounds dramatic.
Because he saw the danger. If courts started striking down laws passed by the people's elected representatives, weren't they just setting themselves up as a new kind of unelected legislature? Weren't they violating separation of powers from the other direction? He was genuinely worried about judicial overreach.
But how did they resolve it in Caton?
In the end, they affirmed their duty. Their ultimate loyalty wasn't to the legislature, it was to the Constitution, the fundamental law created by the sovereign people. So yes, they had a duty to notice if the legislature stepped outside its delegated authority. They were protecting the people's law.
Okay, and this gets hammered home again in another Virginia case, Camper v. Hawkins, about a decade later.
Right, 1793. Here, the legislature tried to give certain judges new powers without following the constitutionally required appointment process. Judge Spencer Roane, another giant, initially doubted the court's power but came around. He concluded the people were the only sovereign power, and the judiciary must refuse to enforce a law that was expressly repugnant to the Constitution or its fundamental principles.
And St. George Tucker was in this case too, right? Saying the legislature can't change the Constitution?
Exactly. Tucker reiterated that since the people hold sovereign, unlimited, and unlimitable authority, the legislature, their agent, can't alter the fundamental rules without destroying the foundation of their authority. The courts, therefore, had to treat such unconstitutional laws as void.
So Caton and Camper established judicial review, but critically, as a function of being co-equal defenders of the people's constitution, not as a supreme branch.
That's the vital distinction. They saw it as a necessary check within a system of separated powers, enforcing the people's will against legislative overreach. It wasn't about judicial dominance.
And this limited view is pretty much what Alexander Hamilton described in Federalist Number 78, trying to sell the Constitution to the public.
Right. Hamilton framed it very simply. The Constitution is the people's instructions. The legislature is the agent. The court is just another agent making sure the first agent follows the instructions. His example was straightforward. Constitution says you need 2 witnesses for treason. If Congress passes a law saying 1 witness is enough, the court must enforce the Constitution's 2-witness rule.
That kind of review enforcing clear textual rules doesn't sound very controversial. It's not the court making policy.
Exactly. It's applying clear rules. The problem, the controversy that Pendleton foresaw, arises when courts go beyond that, when they start substituting their judgment about policy or reasonableness for the legislature's judgment. And that brings us, inevitably, to Marbury v. Madison.
Right, Marbury, the case everyone points to as the origin of judicial supremacy. But we absolutely have to understand the political explosion happening around it.
Oh, absolutely. You can't understand Marbury without the Revolution of 1800. This was the incredibly bitter election where Jefferson's Republicans defeated Adams' Federalists. It wasn't just politics, it felt existential. The Federalists, generally distrustful of popular rule, were being swept out.
Right.
And what did they do in their final days?
The infamous court packing scheme, the Judiciary Act of 1801.
Yep. Created a bunch of new federal judgeships, and lame duck President Adams scrambled to fill them with loyal Federalists before Jefferson took office. Jefferson saw it clearly. The Federalists were retreating into the judiciary as a stronghold to fight against the popular will from the bench.
And the Chief Justice who decided Marbury, John Marshall, he was deeply involved in this.
Unbelievably so.
Yeah.
Marshall was Adams' Secretary of State right before becoming Chief Justice. He was literally the guy whose office failed to deliver William Marbury's commission as a Justice of the Peace. And then he presides over the case about that very commission without recusing himself. It's staggering by modern standards.
Okay, so given that intense political fight, how did Marshall manage to write an opinion that asserted judicial power without getting immediately crushed by the Jefferson administration? Here's where it gets really interesting.
It was a masterstroke of political maneuvering, really. Marshall found, yes, Marbury had a right to the commission. Yes, the law seemed to offer a remedy, a writ of mandamus ordering the new Secretary of State Madison to deliver it. But, Marshall concluded, the Supreme Court couldn't actually issue that writ. Why? Because the part of the Judiciary Act of 1789 that supposedly gave the court that power was itself unconstitutional.
How so?
Because, Marshall argued, it tried to expand the Supreme Court's original jurisdiction, the types of cases it can hear directly beyond the specific categories listed in Article 3 of the Constitution. Congress couldn't just add to that list via a regular law.
So he struck down a small part of a law asserting the power of judicial review, but did it in a way that denied power to his own court in that specific instance and avoided a direct confrontation with Jefferson.
Precisely. It was strategically brilliant and legally quite modest. Marbury essentially said the same thing as Camper did at the state level. The judiciary must obey the Constitution as the supreme law when it conflicts with a statute in a case properly before it. It affirmed co-equal judicial review. It absolutely did not declare the judiciary supreme over the other branches. If it had, you can bet Jefferson would have reacted explosively.
And Jefferson's view confirms this, right? His idea of departmentalism.
Yes. Jefferson was clear. He believed that allowing judges to decide the Constitution's meaning for Congress and the president would make the judiciary a despotic branch. He argued strongly that each department, legislative, executive, judicial, was co-equal and independent, with the right to decide for itself the meaning of the Constitution and performing its own functions.
And who was the ultimate check in Jefferson's view?
The people. Through elections. The Revolution of 1800 itself was the people acting as the ultimate arbiter, correcting the course of government.
So, Marbury, ripped out of its historical context, stripped of the state precedents, ignoring Jefferson's departmentalism, has been twisted over the centuries.
Completely misinterpreted. It's been retrofitted as the foundational text for judicial supremacy, a doctrine Marshall likely never intended, and Jefferson explicitly rejected. Instead of co-equal interpreters, the court started acting, especially later in the 19th century, like it had the final binding word. Popular sovereignty started to fade.
Okay, so when did this shift really accelerate? When did the court move from just enforcing clear constitutional texts like the two-witness rule to essentially making policy?
The main vehicle for this transformation was the court's reinterpretation of the due process of law clauses in the 5th and 14th Amendments. That phrase became the key to unlocking judicial policymaking.
Let's pause on due process. Historically, going back centuries to Magna Carta, what did that phrase mean?
It had a very clear procedural meaning. It meant the government had to follow established fair procedures, the law of the land, before depriving someone of life, liberty, or property. Notice, a fair hearing, a neutral judge. It was about how the government acted. Alexander Hamilton was explicit on this. He said, due process related only to court proceedings, never be referred to an act of the legislature. It wasn't a check on what laws Congress could pass, only on how individuals were treated under those laws in court.
But then came the invention of substantive due process. How did they make that leap?
Well, the court basically started saying that the Due Process Clause didn't just protect fair procedures, but also protected certain fundamental substantive rights from government interference, even if fair procedures were followed. And crucially, the court gave itself the power to decide what those unenumerated rights were and whether a law unreasonably infringed upon them. Suddenly, judges were evaluating the wisdom and reasonableness of the legislation itself.
So they moved from refereeing the process to judging the substance of the law. And the classic example of this in action is Lochner v. New York, 1905.
That's the poster child for early substantive due process. New York had passed a law limiting bakers' working hours. For health reasons, pretty standard workplace regulation. But the Supreme Court struck it down. They invented a fundamental liberty of contract, not mentioned anywhere in the Constitution, and said the New York law unreasonably interfered with it without sufficient justification. 5 justices simply decided they knew better than the New York legislature about bakery regulation.
So the court just substituted its own economic theory and policy preferences for those of the elected body.
Absolutely. It became, as critics called it, a super legislature. This continued with cases like Adkins v. Children's Hospital in 1923, where they struck down minimum wage laws for women, calling the law a naked, arbitrary exercise of power. The court was openly judging the policy merits, not the constitutionality in a textual sense.
And this power grab, using substantive due process or similar reasoning, isn't just ancient history. It's become the norm for how major policy issues are decided today, hasn't it, across the political spectrum?
Oh, completely. Look at Roe v. Wade. Whatever your view on the underlying issue, the court essentially wrote a detailed legislative code, the trimester framework dictating abortion policy nationwide. That wasn't interpreting text, that was crafting policy.
And more recently, you pointed to Kennedy v. Louisiana in 2008 as a really stark example of the court relying on its own judgment.
Yes, that case involved the death penalty for the rape of a child where the victim didn't die. The court struck down the law allowing capital punishment in that instance, and the reasoning was quite revealing. They mentioned an alleged national consensus against it, a consensus the court itself often helps create by its prior rulings. But then they explicitly added a second factor, the court's own independent judgment.
Their own judgment.
On whether retribution, as a justification for punishment, was sufficient in this case. They literally wrote that retribution does not justify the harshness of the death penalty here. That's not legal analysis. That's 5 justices imposing their personal moral philosophy on the nation.
When the court says it's ruling based on its own independent judgment about morality or policy, that seems miles away from interpreting a written constitution.
It's a different galaxy.
Yeah.
It makes the legislature, representing the people, secondary. And this culminates, perhaps most bluntly, in the Proposition 8 case out of California, Perry v. Schwarzenegger.
Right, where a federal judge struck down a state constitutional amendment passed directly by the voters defining marriage.
And the judge, Judge Walker, put it in black and white in his opinion. This is the key quote, the ultimate statement of judicial supremacy. That the majority of California voters supported Proposition 8 is irrelevant.
Irrelevant, wow.
If the expressed will of the sovereign people amending their own fundamental law is irrelevant to an unelected judge, well, then popular sovereignty is dead. The judge is the sovereign, not the people. We arrived at judicial monarchy. The court is now arguably the most powerful and least accountable policymaker in the entire American system.
Okay, if that's the situation, if judicial supremacy has effectively overthrown popular sovereignty, what can be done? Are there ways for the people, the actual sovereigns, to reclaim their constitution?
Well, the first line of defense should always be the judiciary itself embracing self-restraint. This idea, often called Thayer's rule or the doubtful case rule, is simple. Courts should only strike down laws when the conflict with the Constitution is absolutely clear beyond reasonable doubt. Plainly repugnant, as Marshall himself put it in Marbury.
So if it's debatable, if reasonable people could disagree on whether the law is constitutional,
the court should defer to the legislature. Let the political process, the voters, correct unwise laws. Judges shouldn't step in just because they think a law is bad policy. That requires humility, though, which seems in short supply.
Assuming that self-restraint isn't forthcoming, what structural checks do the people have acting through their elected representatives?
There are several constitutional tools, some dating back to the founding era. Remember Judge Pendleton, who worried about judicial overreach in Caton? He later proposed a mechanism, removal of judges by a concurrent vote of both houses of Congress. This wouldn't be impeachment for high crimes. It would be a political check, allowing the elected branches to remove judges who consistently abuse their power or usurped legislative functions. The mere existence of such a check might encourage restraint.
So target the personnel. What about targeting the decisions themselves?
Another idea is to give the elected branches, Congress, plus the president, some kind of override of power over certain types of court decisions, specifically those that seem primarily based on policy judgment rather than clear text. Imagine if Congress and the president could, by majority vote, nullify a ruling like Kennedy v. Louisiana, which explicitly rested on the court's own independent judgment. It would address the policy usurpation directly, without necessarily removing the judge or affecting their tenure for regular cases.
Then there's the power explicitly given to Congress in Article 3, jurisdiction stripping.
Yes, the exceptions clause. Article 3, Section 2 clearly states the Supreme Court's appellate jurisdiction is subject to such exceptions and under such regulations as the Congress shall make. Congress has the explicit constitutional power to tell the Supreme Court, you cannot hear appeals in this particular category of cases. They could, for example, strip the court's jurisdiction over cases involving abortion or school prayer or the definition of marriage.
And if Congress did that, what would happen? Where would those issues be decided?
The cases could still be heard in lower federal courts and state courts, but the Supreme Court couldn't impose a single nationwide rule based on its policy preferences. The issue would effectively return to the states or remain decided at the circuit court level. It takes the ultimate policymaking crown away from the 9 justices.
And finally, there's the structure of the judiciary itself. Life tenure seems problematic if judges are acting like legislators.
Absolutely. If judges are making policy, lifetime appointments with no accountability are deeply undemocratic. Judicial selection reform is crucial. Things like fixed term limits, maybe 10, 15, 18 years, would ensure that justices remain accountable to the constitutional framework and the public over time. Combining term limits with some form of appointment process that requires broader consensus could help.
Makes sense. Accountability needs to be built back into the system. And you mentioned one other potential check, going back even further, the role of the jury.
Yes, this is often forgotten. The founders, particularly the anti-federalists, saw the jury as the ultimate democratic check within the judicial branch itself. We saw that Chief Justice John Jay, in an early Supreme Court case, Georgia v. Brailsford, actually instructed the jury that they had the right to judge both the facts and the law.
Judge the law, meaning the jury could decide if the law itself was just or constitutional.
That was the understanding. If a law seemed fundamentally unjust or clearly repugnant to the Constitution, think of something like the Alien and Sedition Acts, the jury, as representatives of the people, could refuse to convict under it. They could nullify the law in that specific case.
Wow. Re-empowering the jury as a check on both legislative and judicial power. That's a radical thought today.
Maybe a necessary one if we're serious about restoring popular control over the law.
So looking back at this journey, we've gone from kings claiming divine right to parliaments claiming absolute power to the American experiment vesting sovereignty in the people, only to see it seemingly drift towards a new form of sovereignty, judicial supremacy.
That's the arc. And it's crucial to understand that judicial supremacy wasn't the founders' plan. It's a later development, a distortion of the original concept of co-equal judicial review. It has transformed the judiciary into something resembling the unaccountable rulers the revolution was fought to overthrow.
The Constitution ultimately belongs to the people. It doesn't belong to Congress or the president or the courts exclusively. All our agents all need to be accountable.
And that brings us to the final thought, really for you, the listener, to consider. For centuries, the fundamental political question was who rules. Power shifted from king to parliament to the people. Now, a significant amount of that ultimate interpretive power seems to have landed with the judiciary. So the question for you, as part of that sovereign people, isn't if that power needs checking. The question is, how long will you allow an unelected, unaccountable branch to be the final word on your fundamental law? How long until the sovereign reclaims its authority? That, as the founders knew, requires perpetual vigilance.
Well, that's about all the time we have. You've been listening to The Deep Dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shape liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.